We are moving towards the last session of today, that is the panel discussion over industry perspective, uh, panel discussion on the Madrid system experience. Moving forward with the introduction of the various panelists, we have Mr. Jatin. He is a Commerce and Law graduate and the fellow member of the Institute of Company Secretaries of India. His career chart grew to the position of Vice President Finance, Company Secretary and member on board at Claris Life Sciences in July 2003. At present, Mr. Jatin is Joint President, Legal and Company Secretary at Adani Group, heading the functions of legal and secretarial at group level. He has an experience of more than 35 years and has been with Adani Group for more than 18 years. He has worked on variety of subjects like M&A, indirect taxes, corporate laws, litigations, arbitration, trademark, IPR, joint venture, contracts, agreements, corporate governance and compliance, dealing with various regulatory authorities like Ministry of Corporate Affairs, stock exchanges, SEBI, RBI, etc. He is instrumental in drafting and putting in place various internal policies like insider training, whistleblower, anti-corruption, code of conduct, CSR and more. Apart, he is actively involved in social activities through Lions Club. He was the president of Lions Club of Ahmedabad City in year 2008 to 9. At present, he is director CSR at Lions Club and president of Dasha Shrimali Vaishnav Samaj. He is vice chairman Legal Task Force of Gujarat Chamber of Commerce and Industry. He is an invitee member of Governing Council, Ahmedabad Management Association. He is a member of Corporate Laws Committee at FICCI at national level. He is chairman of Legal and Regulatory Compliance Subcommittee at FICCI, Gujarat. He is chairman of Dispute Resolution Committee, CII, India. He is the member of the Academic Advisory Board at UWSL University. Moving ahead, we have another panelist, Mukund Thakkar. Mr. Mukund Thakkar is a graduate in Commerce, Bachelor of Laws and a qualified company secretary. He has a rich experience of more than 32 years in corporate legal environment and has worked with reputed organizations like Zydus Life Sciences, Interglobe Enterprises, Bharti Airtel, and law firms like Mulla and Dua Associates. Over the years, he has acquired insight into functioning of various industries and service sectors and acquired experience in strategic planning and investments, intellectual properties, corporate governance, and board strategies. We have Tejendra Pal Singh Oberoi. He is the Executive Director of Signet Infotech and Chairman of the Indo-American Chamber of Commerce Gujarat branch with 34 years of experience in technology, business strategy and global trade. At Signet Infotech, he has been instrumental in driving digital transformation and innovation, expanding the company's global presence and delivering cutting-edge technology solutions. We have Mr. Jatin Trivedi, a seasoned IP lawyer with over 2 decades of experience in intellectual property rights law, possesses a forward-thinking mindset and a knack for simplifying complex issues, renowned across the legal community for his lateral thinking and advisory skills. Mr. Trivedi serves as a legal advisor and consultant to the MNCs and overseas clients. His expertise spans contentious and non-contentious IP matters, offering bespoke counseling to enhance clients' business, elevate IP exploitation, and increase corporate valuation. I request ma'am to continue with the session. You may start the session.
Let's start the panel discussion. In the contemporary global landscape, the significance of cross-border reputation and expanding international footprint of companies are increasingly apparent. Intellectual property has emerged as a vital component of business strategy, particularly in light of the surge in counterfeit products and malicious trademark registrations in foreign markets that aim to take advantage of established brands. In this context, the international application under Madrid system, facilitated by World Intellectual Property Organization, presents an exceptionally effective solution enabling applicants and businesses to secure worldwide protection for their brands through a single application across approximately 131 countries, thus serving as a formidable asset. In an age characterized by globalization, trademarks are essential in establishing a brand's identity and protecting it across international boundaries. For Indian enterprises, the necessity for efficient processes to obtain global trademark protection became increasingly important as their presence in international markets grew. Acknowledging this requirement, India joined the Madrid Protocol on July 8, 2013, thus becoming its 90th member. The Madrid Protocol, managed by WIPO, offers a centralized and economical approach to trademark registration. India's entry into the Madrid Protocol represented a significant turning point in the nation's intellectual property framework. This international agreement, overseen by the WIPO, enables businesses to obtain trademark protection in various countries via a single application. For Indian brands aspiring to penetrate global markets, the Madrid Protocol has streamlined procedures, lowered expenses, and broadened international outreach. Nevertheless, this path is not devoid of obstacles. Today, we have the opportunity to engage in a dialogue with the Indian industries regarding their experiences with the Madrid Protocol. This discussion will focus on evaluating its implications, benefits, challenges, and potential future opportunities for strengthening global trademark protection. We, Office of CGPDTM, along with the WIPO, are keenly anticipating feedback from representatives of the Indian industry and their legal counsel. Your valuable insights would be greatly appreciated. Sir, my first question is to Mr. Jadin Jalundwala. Sir, how does the Adani Group, which has diversified area of businesses and service sector from Mumbai to here, everywhere I am saying Adani, Adani only. So my question is to you, sir, how your group approach global brand protection and where does the Madrid system fit into this strategy? From the earlier section, we have seen that you have filed 17 applications. Comparatively, I think that number is very minimal, I would say. Now it's up to you, sir.
Hello, thank you, ma'am. Yeah, Adani Group is a conglomerate and have presence in various businesses. Infrastructure is the base. Apart from that, if you see, we are in real estate, we are in power, energy business, solar business, then consumer products. So many things we are covering. So it is essential for the organization to see how our trademark is protected. And the protection of the trademark, the base system is Madrid system. Without that, it will not be possible to get a safeguard or protection. So what as Adani we do, we first have the meeting with the business because they know well where they are going for the business, what type of businesses they are likely to do in various other countries, and what type of trademarks, other things they are likely to want to be registered. One important basic trademark, what we have said is Adani as a name. Then what we do, after we realize that these are the trademarks we wanted to register across the globe, then we have to see under which class we will go. It's not that we should go in all 45 classes or all the classes. It's not that important. We will classify which classes are important and relevant for Adani Group, and for those classes, we will make an application through Madrid system. Madrid system, you all know, the process and other things have been explained well in detail. It's a system which is very useful to all of us. It's a single window, and we can sit at our office and can file an application online. There is no language barrier. You can have one application, composite application for all the countries. So what we are doing, we take the help and advice of our local consultant, let me say YJ Trivedi, Jatin Trivedi and the team, and they help us to find out where to do it. After we submit them the report, this is our wish list, and therefore there is an advice we get, we should do this one application through Madrid across the globe. And that way we try to make an application. Then we have a legal robust team internally who takes care how this application has been followed in various countries. What is happening at that place? What is the status of the application? Suppose we receive the objections, how to overcome those objections? And thereafter we thought this trademark is registered. One of the trademarks was registered first by New Zealand. Within 12 months it was registered, and thereafter, one after the other, we got registration from various other countries. After the registration, we also see how this is protected, and that is very important, because once you are registered, you cannot slip over it. You should see how other people are using it, how misusing it, and that has to be taken care. Every month, I think we shall get it audited from our trademark team, and wherever need, we take the consultant advice. Similarly, some places you see Madrid is definitely about 130 countries. But some countries you all know where the dual system is required. In that case, we also engage the local consultant there, and that local consultant is always helpful to find out what else you require to get it registered. So this is the way we have an approach, initial approach we can say about the Madrid system, through Madrid system, how we can register our trademarks.
That means, sir, you are the good beneficiary of Madrid system.
Yeah, definitely.
And you
we
are
the good, yes,
securing
yes.
all your valuable rights across the country, across the nation and country also through Madrid system. So
That's, let me tell you, before 2013, Madrid system came, I was in a pharma company, and we were running around from pillar to post for registration at various countries. Yes. And today it has become easy by this Madrid system.
Okay. Sir, can you tell me any challenges you have faced internationally?
Yeah, definitely. There are, when we go for registration, there are various challenges happening, like you can say jurisdictional challenges, because every jurisdiction has its own some act, some laws, some rules, regulations, and in that case we have to encounter those things, how we are satisfying or complying with the need of particular country. Secondly, we receive sometime, we can say, some rival industries. They also oppose, and they say this particular name may not be registered. So like in China, sometimes we receive a lot of opposition, this name may not be registered. Then we give the justification, and that after the justification and a lot of representations, we got it registered. Important also, cultural challenges also we receive. Because you know, there are different culture going on at every place. Like example, we can say Om. Om is our India. We are feeling Om is, and we are having Om as our God name. But that may not be that true with the other countries. Similarly, when we go for registration Adani as a name, then so many countries in Australia and other places, the word Adan, A-D-A-N, is going on. And therefore, there is very difficult for us to get it registered and convinced. Because Adani as a surname is useful or known to India as a lot, but other countries may not be knowing to that extent. And so to convince the one registry also has become a challenge for us. So apart from that, so many other challenges we receive, like counterfeiting. It's a very important imitation. Because wherever you go, say one example I must give you. Uh, there is a website in Australia, which is Adani Watch. And if you go for Adani Watch website, it's known to everyone, so it's not that I should not disclose or I should not tell. Because this Adani Watch always put negative news about Adani. So that's the Adani Watch. They have opened someone in Australia when there was environment issues going on. And then we fought it for that also. Okay, this Adani is a name we have registered, Madrid and all this. And therefore, this particular Adani Watch website has to be either restricted or to be used in a particular way. So these are all challenges we are facing, or any other corporate also might be facing when it goes internationally.
Sir, I know when the company corporate becomes big, the problems also will be big. So if the time permits, I will come back to you, sir,
Thank
to
you.
hear more about from you. Then next, my question is to Mugund, sir. Sir, how does the Madrid system help the CIDES streamline global trademark filings?
Right. So before I answer that, I think Jatin bhai, that Adani watch should become Adani stopwatch. Should stop them at no matter what. Okay, so Zydus, as you know, is a pharma company. And pharma company has one of the most important assets that a pharma company has, apart from the technology, is the trademarks. We have almost 4,000 trademarks, out of which 600 are international trademarks. So and that goes with most of the pharma companies. So it's very, very important for us to protect our trademark. But it is equally difficult to get the trademarks because all pharma companies are under one class, and usually preferred suffixes or prefixes are the molecule name. Now imagine a situation where 10 pharma companies on day one launches is coming up with a launch across globe wherever that patent is expiring with similar sounding brand names. How difficult it becomes. Obviously that's the challenge that a pharma company has. Now when it comes to Madrid system, so we started using it I think a decade ago. We have seen that it becomes very efficient for us when we are going to at least 10 countries or at least 8 to 10 countries. If it is less than that, then we kind of go conventional way. Another thing is, because we have diverse markets where we sell our products, and each of those products take time for registration and all of that, not all our trademarks are simultaneously launched in many countries. So the first time proposal will come for 1 or 2 countries, those markets, in emerging market for example. Then after 6 months, 8 months, they'll say, okay, we want to now use this product for these 3 countries. So Madrid system that way doesn't become so efficient for us. But yes, there are many launches where, especially the new products, so if it is more than 10 countries, then we make Madrid application. That becomes very easy because it's cost effective, and the same language, one language we can do everything in that way. So that's our experience with Madrid system.
Okay, sir. One more question. Which international markets have been the most challenging in terms of trademark approvals for CIDES?
See, each of these markets are different in terms of, as Jatin bhai was saying about the culture, and their examination procedures, their kind of oppositions that we get. Sometimes in some countries like US and all, we have seen a lot of trademark squatting happens. So they are very smart, and they would know that kind of some such trademark, especially when you're talking about, so they would just buy those trademarks and keep them, and then they start negotiating $1,500, $2,000. Sometimes they start with $10,000 and then they come down to $2,000, $3,000. Otherwise they'll file oppositions, and then once I start defending that, I'm anyway going to spend that much money on the lawyers and the system. So I might as well buy. So, but I've seen, that's why when it comes to USA, we go solo generally. Our use of Madrid system is mainly for Eastern European countries and Southeast Asian countries. That it's very efficient that way. Thankfully, all our applications have been registered so far. So no problem vis-a-vis that. But yes, examination procedures and rules on all of these are challenges sometimes.
Now let us hear from our IT giant, Tejinder Oberoi, sir. Sir, this is the first time we are getting an IT professional to this platform. So, sir, how important is international trademark protection for an IT company like Cygent Infotech?
Well, some of the best intellectual property that is coming up in the IT world. You have maximum startup ecosystem coming up here, and the fastest and the lowest barriers for international trade happen in the IT industry. So it's easiest for them to go global. Even a startup with virtually no infrastructure has capability to go global. Even if he doesn't have any visa stamps on his passport, he can still be a global exporter. In such scenarios, being able to build a brand which he is able to take across the globe is a very, very vital thing. And investing into a Madrid registration will definitely be a very, very useful thing, because one, scaling up is probably one of the easiest with the IT industry. So you take brands like Zomato or Swiggy, they have gone for Madrid. They were technology companies, and it has been very easy for them to take up these brands there. So possibly the next, like pharma is definitely a very big user, but possibly the next surge of trademark registrations should come from IT industry, or at least the technology brands. That's what I would possibly like to put.
Sir, one more question to you, sir. With the increasing cyber threats and domain name disputes, how does Signet ensure its brand security internationally?
Well, this is an important question. We've been facing challenges of similar looking names and domains being used by others across. We also face a very similar scenario wherein people try to come in because there are so many domain extensions available. So you have a scenario wherein people book those domain extensions and then try to trade it off. So you have to see what is useful, get into a negotiation and trade off some of them, which is not useful. Sometimes you have to live with it or ignore it. But then there is a industry segment operating which virtually thrives on such practices. And you have to try and be safe. Whatever is critical as domain names, extensions, you tend to register for all those domain names.
So you are not advising litigations?
Litigation for, see, I'm an entrepreneur. Litigations is the last thing for an entrepreneur. Litigation, you get into a litigation, I would rather suggest protection. You do the right kind of agreements, you do the right kind of notices, but litigation is not, unless it is, you don't have a way out of it, because in most cases we do not even know the party we are fighting. They're invisible in this digital world. So who will you fight? Who will you litigate with? Even if you have if you served a favorable judgment, whom do you go and apply it at? So you have those kinds of challenges. Litigation is not for business. I think protection is more important than litigation.
Yes, sir. Even Jadin sir also agreeing with that. It is little disheartening for our IP fraternity, those who are in callers, but what sir said is exactly correct.
I think protection is the key, and I think the legal fraternity should help us protect protect and guide us on how we can protect better.
Yes, sir. I recall a particular case, legal case occurring in Germany. While I prefer not to disclose the trademark, we shall refer it to as ABC. ABC is a well established and a highly regarded clothing brand recognized for its quality and longevity in the market. The company received an offer from Germany and subsequently exported its products there. However, ABC India later encountered an infringement lawsuit in Germany, as the trademark ABC had already been registered by a German national. ABC India does possess defense such as transporter reputation and prior use. Nevertheless, substantiating these claims necessitates robust documentation and incurs significant litigation expenses. I think Jadin sir also will agree with that. Yeah. And we all know how difficult it is to get documents from corporates to prove something. So, in my opinion, the costs associated with the prosecution are relatively minor when compared to the overall litigation cost. Furthermore, when engaging with the corporate entities, obtaining the necessary documentation to demonstrate usage by can be quite challenging. I propose that we develop a strategy for corporations that emphasize the notion that investment in prosecution can reduce litigation costs by 99%. This was my closing statement, but when sir told regarding litigation and all, so I thought this will be apt for this time. So we have to educate the corporate sector, not only the legal sector, the marketing and the financial department, because so many times, even I think Jadin sir also may had the corporate legal in-house people, they comment like that, okay, we can understand all these things what you are recommending, but our financial department, they don't understand. So I think we have to educate the corporate sector. Is it, sir? Sure. So my question to Jadin sir, what are some of the most common mistakes companies make when using the Madrid system?
Right, so thank you, ma'am. But just taking a point which lastly was Tejinder has said, how many of you are aware of that there are countries where the brands which are registered once cannot be cancelled? There's no cancellation provision. How many of you are aware that their country exists like such? Anyone? All right. So my experience is, I believe if it is still, I'm referring to an act of Nepal trademark law, and it does not have a cancellation provision at all. So if somebody holds a trademark registration and there is a border on the northeast side, which is, they call it as a Birat Nagar border. Now that Birat Nagar border is open for India-Nepal trade. So most of the things travel from India, manufactured in India, route through West Bengal, each reach to a Birat Nagar boundary, and Birat Nagar boundary, they get an entry at the Nepal. So that's the normal trade track. Most of the products manufactured in size of, say, for example, a quantity in one truck, you will find at the Birat Nagar boundary cross, you will find at least 5 trucks lying with the same product, identical getup and everything. So it has so happened that some years back, I personally went there to, litigate that matter, and we got to know that the other party who is duplicating this product, they holds the registration of the very. So we went there and unaware about that, whether there is a provision of cancellation or not, and realized that there is no provision of cancellation. So ultimately my client had to sit on the table and negotiate, which was quite a huge amount. So, and that was none of these two corporate, but one of the other corporate from Gujarat. So I personally believe that, as he rightly said, the protection is more important than the litigation, because ultimately, if you are not well protected, that will lead to a litigation. And so, as you should avoid, which is multiplying the cost, which is multiplying the efforts, and at the end, you are not sure about the. And as rightly Mukund Bhai has said, if it is, I have to spend this much amount, which I'm otherwise going to spend for the billing of the lawyers like us, so why not to buy it, right? So that's a very sensible decision, and I would recommend that everybody should do so. Coming to the point, question, ma'am, which you have asked me is about the mistakes, correct me if I'm wrong, which you have asked
Yes,
for, right?
yes.
So most of the, as a practitioner and when I was serving as a 1.5 year as a consultant, and I traveled to the Bangladesh and Sri Lanka for a session of Madrid, most of these countries and the applicants have the applicant, I refer to a trademark applicant, they have a misconception that there is an international registration. There is no international registration. David, correct me if I'm wrong. There is an application which you are making, and every country has their own examination system, and they will examine. So your application will be registered, but your trademark will not be registered until those countries, that is 130 plus country, pass through that process, they examine in their way, and then if it is found similar to an earlier mark, which is a law in India, the same law applicable most of the countries, and then that case, if it is not registrable, that part can be hold on and remaining can proceed. But there is no international registration. There is an international trademark application. So that is one misconception or mistakes what people have done. I hope I'm right, maybe, right? I hear you discussing internally. Yeah.
It's a terminological question. Fundamentally, you're right. So it's absolutely true and it's the same for PCT. If you use PCT or Madrid, it's not that if you're successful that you get some title that covers the whole world. It doesn't exist. So for both Madrid and PCT, at the end of the day, the application is examined by each country separately, and you will get the right or not in each of these countries. So that's correct, and that's the fundamental point that you're making. But terminologically, and this is often a case, causes a lot of confusion in the Madrid and Hague systems. When WIPO receives the application and the formalities examination is done and there's no more problems with the application, we do register it in our registry. It's called an international registration, but it's not a grant. So I think fundamentally you're right. Just to know that when you hear talking about international registration in the Madrid system, it's not like a grant by a country. It just means that WIPO has done the formalities examination and that it's now in order, and then we send it to the countries for the substantive examination, and then they decide whether they grant it or not. And that grant or the refusal will come also to WIPO to be registered in the database. So that's.
Thank you, Mr. David, for the clarification.
Thanks,
I
David.
think the terminology what you are using for registration. See, in our country, regionally, we use it as registration. But in WIPO, the protection is grant of protection. So because of the terminology, this confusion created among us.
So
Okay.
I stand correct myself, David, for the part of the terminology is that your application to a Madrid may be registered, but your trademark will not be registered in that respective countries, correct?
Sir, for them it is
It's
grant
a
of
grant.
protection.
All right, sorry. So use the grant. Okay. So coming to the next myth is that there is a belief of the applicant that mother country application can be escaped and you can straight file to the international application, which is not the case here. So mother country application is a base for at least 5 years for the Madrid, and that is. These are the two mistakes normally people do, that they file an international application, we then believe that it is registered in almost all 130 countries. But it will be registered in the designated countries, and accordingly you need to pay the fees. So these are the two major misconceptions I understand that people have.
Thank you, sir. I have one more question to you. Sir, you know nowadays our government and Honorable Prime Minister is encouraging the startups and MSMEs. So my question to you is, for MSMEs and startups, how does Madrid compare to national trademark registrations in terms of cost and efficiency?
I think we talk in the morning, so it's a very easy answer for me as of now. But MSME and the startup, I would say that it is the best product and best process which you should adopt. The reason is that it is a cost efficient, it's cost effective, right? Any MSME or any startup who is spending or investing in the brand protection, they will be drastically saving the money and huge money behind process for filing the trademark application at the respective regional offices in a conventional method. So that is the one most attractive benefits for any startup or the MSME who is having a budget for protecting it. Second is that through Madrid, you can easily manage and navigate your intellectual property rights, mainly a trademark rights. That will save a huge money further not to have, to JJ and the Mukund the expensive in-house counsels who takes care of the trademark and managing the trademark portfolios. But coming to the point is that, it's very important for you to, at the initial stage of your entrepreneurship journey or enterprise journey, to save the cost. And two part is very essential. One is when you file an application international, you save the cost. And second, you don't need a huge infrastructure to manage the things, because all renewals, all changes can be filed at one go. So that's the most beautiful benefit of the Madrid for the MSME and startup, and I highly recommend for the same.
Thank you, sir. Sir, I have examined the data concerning Madrid applications originating from India. According to the findings, the numbers of IAOI means applications filing in India to transmit to WIPO. Filings are gradually increasing in every year. However, it is below 500 in numbers, while there are approximately over 4 lakhs national applications submitted annually. So, sir, can you tell me why this less number of filings before WIPO?
That also probably me and David had talked about in the morning. And, my experience says that leaving a few corporates out of this, all the numbers which has been filed through any region, like say, take an example of the Gujarat, right? I believe the 30% or a 25% or maybe a less must be filed through in a corporate when it comes to a trademark filing, right? Remaining are being filed through either a startup or the mid-sized enterprise SMEs, or maybe the young entrepreneurs. When I say young entrepreneurs, not by the age, but entrepreneurs at the age of the enterprise. Now, if you look at to that 10 years or 15 years of an enterprise, these are the people who make an application to a trademark registration. These are the people, as he rightly said, these are IT companies, there are food chains. Today, if you travel to US or Europe, you will find many Indian food outlets is established in those part of the countries, those part of the world. And these kind of people who need to be targeted for the Madrid process to be adopted rather than filing the conventional application, they will definitely opt for, and as I said it in earlier answer, that it will not only efficiently they are able to manage, but also they will save a huge cost. So my belief and my understanding is that these numbers is not only by the corporates. So we are focusing currently on the high-ended corporates who's spending or contributing 30 to 40% in filing of the Indian applications. We should also focus equally on those remaining 60-70% who are below 20 years of age in the enterprise journey. So that is where we need to target and we need to focus on.
Sir, I think Mr. David wants to say something on this.
Thank you. Just to follow up on what was just been said with regard to the number 500, I think there are three things to bear in mind. So the tendency is always to compare that number. So these are 500 applications that go through the Madrid system, and we tend to compare it to the number of national applications, which is indeed much higher. But you have to bear in mind, if the statistics for India are the following. In terms of national applications, India is the fourth largest filing country. So your country is the fourth in rank in terms of number of national applications, which is huge. But in terms of how many applications Indian residents file abroad, you're not the fourth, you're the 38th. So for us, that means that you're on the verge of having a real explosion of trademarks going abroad, but it's just the start of the process. Relatively speaking, you have many more national applications than applications going abroad. Therefore, you should really compare the number 500 to the ones that are going abroad rather than the national ones. So that's the first point, if you allow me. The second point, and I'll try to be short, is if you look at what we count to see where a country stands on its use of Madrid or direct, we compare the number of outgoing applications and how many of those go through Madrid and how many of those go through the Paris route, the direct route. And India is at about 50% in 2023. So half of the trademark applications that are going abroad go through Madrid and half go direct. And I can tell you, for a country that has been member for approximately 10 years to the Madrid system, 50% is quite high. So in some ways, you're using it a lot. But the number is very counterintuitive, I agree with you. You're using it a lot. If you look at the United States, they've been a member for many, many more years than India. And I think the rate is around 60% only. So you're only 10% behind a country that has been a member for a much longer time. So we believe in WIPO that the usage of Madrid in India is already quite mature. There is, of course, always room for growth. And I do agree that the real potential is in these smaller companies, because the big companies generally know what they're doing and they can take the decisions for themselves. But the smaller companies, there's huge potential. But having said that, already we're quite happy with the way the country uses the system. And
Yeah,
my
we should
apologies
really
for my long...
we should really appreciate the movement of Make in India for the real increasing number of applications. Really, sir?
Yeah. So, in fact, no, I was on the point is that Make in India also is a little, take a credit, because Make in India is like a lot of imports. It has affected a lot of imports, so probably the Indian have also stopped exporting because they have already started manufacturing now. So that could be one reason. I'm not sure about, but I'm just saying.
We are, before closing it, we are coming to again.
Make in India, I must say one more thing to add here. Nowadays people are saying Atmanirbhar Bharat, that is Make in India. But now we are converting India Bharat pe Nirbhar. So it's not only India making India, but others should be relying upon India.
Thank you, sir. Sir, one more question to you, sir. What advice would you give to large corporations considering the Madrid system for international brand expansion?
Say large corporates, Madrid system, let me tell, it is a unique system and quite helpful, protective, safeguarding the interest. And large corporates will see how we can best utilize that system. And for that purpose, we have to see which countries you are going for the businesses, which are the most important countries for your business. Similarly, which class of business you are going to enter into, or which classes you are going to any other country. And prepare the list, take the advice of the local lawyers, that is India, and wherever you find it is a complicated situation, shall take the advice of the regional lawyer or the lawyer at a particular country, because there are two different things. One is one we can say major countries where it is important to get this registered under Madrid system, US, then European countries, Japan, other places. Some other countries which are emerging countries where also we have to see how we can best register our trademark. And thirdly, certain countries which are part of the Madrid system, but they are also adapting their own system internally. So those countries also have to be seen, like Canada. So where we have to see how we should adapt the system and how we should go ahead. Apart from that, internally, corporate shall have the awareness program. What you have pointed out to Jatin Bhai, that 2013 before, why there was no much applications or so. So because the awareness was very less, and people were running around from X place to Y place, how shall I get my trademark register? So that awareness within corporate, within the system, some newsletter, some flashing of the news when there is a trademark, some case law has been, important case laws that is to be there. And then our internal audit system, okay, we should get it audited every year or so, okay, my trademark is safeguarded, my trademark is protected everywhere. That is the, I think, I can have advice to the big corporates.
Means a simple registration is not enough.
Right.
Periodically you have to audit yourself. You have to find in market whether any duplicates are there, etc. Okay, thank you, sir. Next question, sir, Mugund sir. What would you suggest to pharma companies looking to register their trademarks globally under Madrid?
So the most important part when it comes to when you're going global is to do your research in terms of the possibility of oppositions, possibility of the mark that you want to go for. See, it's very unidirectional. I mean, I've been working for last almost 3 decades, and whenever it comes to brand launches, the entrepreneurs, the promoters, or the business unit, they decide a name and then say, we'll file this in 20 countries. Now, before that, I tell them that you do your research. That in those 20 countries, how many countries you're likely to face the oppositions of because of the similarity and identical marks. Like, I'll give you an example. On this stage, there are 2 Jatins right now. So, if you have not done your research, you will always have problems where, even though you're going Madrid way, you're going into multiple countries, but your research need not be only India-centric, but you have to do the research everywhere. So that is one part which I feel very, very important. Second is, have a very clear description of the mark, basically goods and services in which you want to apply. So for pharma, it's generally, we know that it's class 5, it's a pharmaceutical product, but being specific sometimes that you want to go for this particular treatment can also avoid oppositions at some places, because they'll say that, okay, other marks may be into some other kind of a treatment, and you limit yourself for this particular treatment. Then, you monitor the deadlines which are there for the applications, legal expertise sometimes you may need, kind of in the respective countries, just in case you have any issues when it comes to oppositions and all. Managing cost also becomes very important, because for us, it's not 1 or 2 or 5 brands. It's like we are talking about hundreds of marks in, kind of 50, 30, 40, 50, 60 countries. And therefore, the costs become very, very important for us. So these are the things for pharma companies especially, this is very important. Thank you.
Mugund sir is giving advice to the corporates over here before jumping into the markets, do your homework. Is it, sir? Yes. They should do their homework.
Absolutely, very, very important.
Now I am coming to Jadinder sir. What role do you see technology playing in simplifying international IP protection, including Madrid filings? Because you know, now ordering food, Swiggy or Zomato, it's just a on your tip of hand only. So, what can you advise?
I think it is technology which has enabled that Madrid can be applied, because you have a central one place to file, and the certification request goes to 130 countries. So it is technology which has enabled this.
131 countries, sir.
131 countries.
Yeah.
And I think it would be a very rare situation globally that 131 countries have agreed to a single process. So that in itself is a very big achievement, because normally we have so many lobbies globally that they don't come and sit together on the same subject. Technology is already enabling it, and technology companies coming up to utilize it in a big way is the next wave that we should see. I think it requires promotion, talking through IT associations to companies can be a very good way of promoting it. I'll definitely use Jatin Bhai and others to promote it on some chambers I am associated with, to be able to tell people how they can protect their brand locally, and we'll take it up from there. Technology will make a difference, and technology is already the reason why you're able to do it in 12 to 18 months.
The final question to Jadin sir. What is if you could recommend one improvement to the Madrid system from a legal perspective, what would it be?
Sorry. No, we laughed on each other because this is the very point we discussed in the morning. So my experience is that first and foremost, as I suggested in the first point, and the answer is I highly recommend this system to be adopted. Not just because I am a practitioner, not just because I was associated with the Madrid sessions, but I believe that it's one of the beautiful policy, as Tejinder rightly said, that there are very few policies or the system where almost more than 130 plus countries agreed to. So that is something which we should respect, and it is really affecting on your pocket. It is also affecting on your time. It also affecting on your management. It becomes very easy to maneuver or navigate your entire IP portfolio. So that's undoubtedly no system default. As of now, if we can have sort of a guideline to the examination process, there are so many unpredictable actions happening during the process. If we can eliminate some way, or we can advise through a guideline coming from the WIPO to the regional examiner, then probably it will be more easy or more smoother for the procedure or for the practitioners or the applicant to run through the objection, because every region have so much so, like as Jatin Bhai has said about the OM, like in India probably OM is not protected, but if I go to the certain region where OM is not as familiar as in other countries like of the Asian country, probably it will be registered. So these are the basic things which we face. On other side, like when it is registered in India, but it is not registrable in other part of the world, that the client is already exporting the business. So, and I had a challenge when I was dealing with there's a famous brand in India I can refer, Atul Auto. So Atul is a general name in India, and we got a registration in India. And when we went to the global, there are certain region where they objected, stating that it is a personal, and we then have to put forward the argument saying that the India is already registered after these all objections, even though the personal name, but it was protected because of the certain condition we met with. So these kind of issues normally often we face at the second stage. First stage, yes, as he rightly said, it will be registered in the system. But the second stage where it transferred to the regional offices, regional officer examiners examine according to their laws and process, there if we have the guidelines would be much better, and that will be something which I would highly recommend. So we can, at least if we can come up with a guideline, may not be changing the whole process, but at least a guideline will be helpful to, in a form of an advisory to the examiners.
So if you ask any company what their ideal state is, it would be there's a worldwide patent, there's a worldwide trademark, because you would have to only argue once with the office to get it. So clearly the fact that the international intellectual property system is still largely a national matter, and each country has its own way of dealing with it, is an enormous complication for anybody who's trying to get it right in all these countries. And it's true, it's our job at WIPO to try to minimize that as much as possible. And basically, the short summary of WIPO history is trying to reduce the diversity to making it more uniform. But that is a very, very long process, and you know, it's not an easy thing for us to tell offices how to do their work. It basically, see, the USPTO, for instance, has a very peculiar product identification approach, which requires a high degree of specificity, which is very different from the European approach. So we appreciate the need for trying to make it as uniform and as simple as possible, but there's going to be a need for a lot of time to get all these countries to agree to make it more seamless than it currently is. Thank you.
Thank you, Mr. David. Before concluding this panel discussion, I would like to express my gratitude for the perspectives shared by all the panelists. Thank you, sir. Thank you for sharing your valuable insights, experiences, and advices to the fellow colleagues sitting over here. Okay, thank you once again. Thank you for the participants also for hearing in patience. Okay.
Thank you.
अभी पेशेंट से क्या किसी को क्वेश्चन आंसर के लिए बैठने का या you can take it offline.
Thank you.
We should wind it up now because our WIPO officials, they are they have to catch the flight, so they want to leave it now.
As we conclude today's insightful panel discussion, I extend my heartfelt gratitude to our esteemed panelists for sharing their expertise, perspectives, and valuable insights. Their thoughts have not only enriched our understanding, but also sparked important conversation that we must continue beyond the session. I also want to thank our audience for their active engagement and thought-provoking questions. Now, I request Ms. Preeti, Senior Examiner of Trademark, GI and Copyrights, to give the closing remarks for the ceremony.
Thank you, Jaspreet. So, for my shortest span in Gujarat, how do we start in Gujarati? It's like Jai Shri Krishna. This is only what I have learned here. So, Jai Shri Krishna. Ladies and gentlemen, as we have come to the close of this event, enriching event, I must say, I would like to take a moment to reflect the key insights over the event which we had gone through. And not only this, I had actually, and I think same feeling will be corresponded by you also, that we had this honor to somehow witness that such great ideas has been and experiences has been shared over this platform on this event. So, and technically for understanding the advantages of PCT, Madrid, and also the WIPO's aim, that to be in respect of bridging the gap of intellectual property ecosystem. So I'm really thankful to you for this thing, sir. This event has not only deepened mine or everybody sitting here in this room has like got their understanding enriched in that scenario, but also one thing I have learned, that yes, innovation is the driving aspect, and also at the same time the commitment is the one important thing which is required to be seen, whether you are an entrepreneur or you are an IPO official, or even if you are a practitioner, or even if you're a common man. This is the one very suggesting thing, that you have to have this practice, that you should be reinforced by these things. Today's interaction must have given you this reinforcement. I'm way too touched by this thing. I would like to extend my heartfelt gratitude towards our esteemed speakers, our panelists, moderators, and definitely not at the least, but our organizing team and partners, which is Ahmedabad Management Association, and definitely to YG Trivedi, Jatin Trivedi sir. Thank you so much. I have seen it in the very rare of case that yes, people from on the other side of the table actually has joined hand on this side of the table, and we have contributed equally. So way too thankful for this. And AMA, Ahmedabad Management Association, definitely thank you so much for this. If anybody sitting here, or if not, then I would request Mr. Trivedi to convey our heartful, gracious thankfulness to them from IPO unit Ahmedabad. And definitely to all the faces sitting here, the participants, thank you so much, because it's your faces only, even if you're tired, since morning you have been till registration desk to here till evening. Thank you so much, because it's your faces that has given us this much enthusiasm, and because we being government official lack the event management skills. So it's you sitting here has actually been very kind of enthusiastic, and you are being very encouraging to us for this scenario. So very, very thank you for this thing. And also, Mr. Binoy, from IPO unit Ahmedabad as well as from India, I was way too touched by your words of Abhar, Namaskar and Namaste. So even we have for you something, and if I am correct and if it's somehow I'm mistaken, to sorry in advances, it is Mercy Buku. So thank you so much. Thank you everyone for being here, for being patient with us, and thank you, sir. I would request each and every panelist and WIPO officials again to be on the stage for a group photograph, so that in the end we can somehow memorial this so-called successful event for the group photograph. I'm inviting everyone and our IP officials also, please. Thank you so much. Thank you again.